is an honor to be able to share with you the reflections suggested to me by the topic of protecting surrogacy-born children. The question that brings us together is, why do we need protection for surrogacy-born children? Some reported cases may provide us with an appropriate context. Most of these are facts that Special Rapporteur Maud de Boer-Bukikyo collected in her report to the United Nations Human Rights Commission on the sale, sexual exploitation, and sexual abuse of children in 2018. Some are more recent cases we all may know. Evidence includes the use of surrogates from India and Thailand by commissioning parents from Australia and Israel convicted of child sexual abuse in their home country. We have learned recently of a similar case in Chicago. The discovery by Thai authorities of 15 Vietnamese women in a case of human trafficking in the context of a baby breeding scheme. The employment of a wealthy Japanese man of 11 surrogate mothers who gave birth to 16 children in Thailand and India. More recently, in a report about surrogacy in Georgia, Unreported World, a documentary series produced by Quicksilver Media in the UK, denounced in 2021 a couple of affluent Turks who obtained 21 children through surrogacy in 2 years. The children were cared for by 17 nannies. Later, the couple would have been arrested by charges of money laundering and fraud. The abandonment of new surrogacy-born child with Down syndrome in Thailand. Similarly, the abandonment of or sale of spare surrogacy newborns of twins in India. In past years, surrogate-born babies trapped in Ukraine, first by the pandemic and then by the war. In its 2021 documentary, Unreported World exhibited shocking images of a newborn separated from her mother at birth until commissioning Chinese parents could travel to pick him up. In January 2021, a Chinese actress was accused of abandoning 2 children of surrogacy in the United States to the care of her occasional partner. Abandonment is a recurrent problem in the industry. In August 2023, newborns from surrogates were retained in a fertility clinic in Greece until the commissioning Australian parents proved a genetic link with the children. The clinic was under charges of trafficking 169 women, illegal adoptions, failed IVF, trade of eggs, sperm, and embryos. The situation would have affected an estimate of 150 children. The separation at birth is reported by grown-up children and surrogates as traumatic in many cases. In December 2022, a British newspaper, The Guardian, denounced an English fertility agency that operates overseas for practices that are prohibited by law in the UK. Among others, the newspaper states that, and I quote, its branch in Ukraine previously suggested babies born with disabilities could be legally abandoned at an orphanage if they were unwanted, telling potential customers from overseas that in the event of their surrogate giving birth to the baby with an anomaly, they had a right to leave the baby at an orphanage. In this case, government dedicated office from government side undertakes the responsibility toward baby, and no lawyer is needed for this. End of the quote. The agency download the webpage after the announcement by the paper. Lastly, I can add the use of a Chilean family court of a fraudulent and colluded judicial procedure to establishing maternity in favor of commissioned women, of surrogates, which has been applied in at least 4 published cases. What conclusions to draw from this evidence? I can just tell you some. First, widespread exploitation and abuse. The examples show a disturbing trend of exploitation and abuse within the surrogacy industry. This includes the use of surrogate mothers by individuals convicted of child sexual abuse and the employment of a significant number of surrogates by single affluent individuals for the purpose of giving multiple children, birthing multiple children. These cases raise serious concerns about the motivations behind surrogacy arrangements and the lack of safeguards to protect children. Second, child welfare concerns. The abandonment of newborns, including those with Down syndrome or spare children from twin births, underscores the urgent need to stronger protections for children born through surrogacy. These instances reveal a commodification of children that are treated as products subject to acceptance or rejection based on desired attributes, in some cases even sex selection, IQ requirements, race, skin color, and the like. In the fertility industry, which includes surrogacy, children are tailor-made products. Third, risk of statelessness, filiation, and identity issues. Children abandoned due to the pandemics or war, or retained until genetic links are proven to be adjudicated to their commissioned parents, face risk of statelessness and identity confusion. These situations illustrate the importance of establishing clear guidelines for the recognition of parentage and nationality in accordance with the Hague Convention on Protection of Children and Cooperation in Respect of Inter-Country Adoption, 1993. 4. Global dimensions of surrogacy. The international nature of many surrogacy agreements involving parties from different countries with varying legal standards underscores the complexity of addressing these issues. The global industry of surrogacy calls for a global ban. Children born from these arrangements, national or international, are human beings, not merchandise. The practice of surrogacy infringes the prohibition of sale of children and the Hague Convention, Adoption Convention. Fifth, calls for a total ban and severe restrictions on surrogacy. The denouncement of an English fertility agency for suggesting the abandonment of babies with disabilities and the retention of newborns pending genetic proof in Greece highlight the urgent need for an international ban on all forms of surrogacy. Any reform should prioritize the welfare and rights of the child, in ensuring that no child is treated as expendable or subjected to abandonment, trafficking, or sale. All children deserve to be treated as human beings, subjects of rights, with inherent personal dignity. Many people think this evidence suggests a pressing need for comprehensive international standards and stricter regulations within the surrogacy industry. They suggest ethical violations and the protection of rights of all involved should be addressed properly. Once this occurs, all over the world, they may reason abuses, as the ones depicted before, would certainly end. They uphold, as we do, that the welfare of children born through surrogacy should be paramount, and that this should include measures to protect exploitation, ensure the legal recognition of parentage, and safeguard of, the rights of children to their identity and protection from abandonment and abuse. I agree with those people in one point. More refined regulations would put difficulties to an industry that deals with human beings, especially the most vulnerable of them, newborn children. However, considering that children are not merchandise or property to anyone, neither their parents, intentional or biological, nor their gamete providers, there should not be an industry or traffic with children of any age, newborns or grown-up. The fertility industry, which is always a for-profit business, has some limits. Tailor-made children on demand and the sale of children are international offenses to human dignity. Children's intrinsic dignity justify a total ban on the practice. In the following minutes, I would like to suggest further policy-making measures to enhance the protection of children, especially donor-conceived and surrogate-born children. Considering the potential UN ban on surrogacy for child welfare, it is imperative to reflect an additional measure that can further protect children involved in surrogacy and donor-conceived children with assisted reproductive technologies. These measures include rigorous suitability screening of commissioning parties, the so-called intentional parents, the abolition of gamete donor anonymity, and the assurance that maternity is determined by the fact of childbirth. In my view, these elements are crucial in crafting a holistic approach to child welfare in the context of assisted reproductive technologies and surrogacy. Incorporating background checks for commissioned parents requesting assisted reproductive technologies, including gamete providers, reflects a commitment on prioritizing the future child's best interest. The screening process will assess potential parents' ability to provide a supportive and nurturing environment, ensuring that donor-conceived children are placed in homes that safeguard their well-being and development. This measure supports the broader goals of a UN ban on surrogacy, emphasizing the protection of donor-conceived children, including those born from surrogates, from potentially exploitative and abusing practices. The idea of a suitability control in the commissioning parties of surrogacy at an even donor request is known in various countries, such as the United Kingdom, Sweden, France, and at the level of recommendations of professional organizations in the United States of America. We do not know exactly the exact efficacy in practice of these texts. However, it's interesting to give them some attention. The suitability control of those accessing assisted reproduction would be a standard in the United Kingdom. According to the Human Fertilization and Embryology Act, fertility treatment centers are required to document an assessment of the patient or patients in prevention of any risk of harm or neglect to the child that might be born from the treatment. Fertility treatments will not be provided to a woman unless the welfare of any child that might be born because of the treatment, including the future welfare and the capacity to care for or meet the needs of a child. Other basics are the patient's commitment to having and raising one or more children, the patient's economic situation, along with their ability to meet the needs of any child or children born as a result of the treatment, the home environment, and the effect of a new baby or babies on existing children. Background checks include the physical and mental health of the patient and their partner, the medical and family history of the partner and their families, the criminal records of the commissioning parents, whether the patient and their children have been removed from their custody, and any other history of child abuse, the potential need of the child to know their origins, even the age of the patient and their probable future capacity are also mentioned. Well, some of these measures are repeated in regulations in the United States of America. Swedish legislation also makes some requirements of these, some checks of the patients that request fertility treatments, and France also. And I pass to the second measure that I wanted to talk about. Even though I believe egg donation or sale should be prohibited, as it is in Germany, the second measure I propose is the abolition of anonymity for egg and sperm donors. The elimination of donor anonymity in assisted reproductive technology is pivotal in protecting the children's right to know their origins. This transparency aids in the child's identity formation and prevents the commodification of human life by treating gametes as mere transactional objects. In the context of a UN surrogacy ban, advocating for a non-anonymous gamete donation underscores a commitment to ethical practices in reproduction, ensuring that children's right to knowledge about their biological origins are upheld. Olivia Morel has amazed us with her brave testimony as a child of surrogacy. Her own experience and search for identity demonstrate that one of these guarantees all legal systems ensure for those born through a surrogate mother is the right to know one's own identity. including one's biological origins. For this, we have some advancement in the 2019, the Parliamentary Assembly of the Council of Europe approved Recommendation 2156, advising the lifting of anonymity for all future egg and sperm donations for assisted reproduction. It is proposed that this elimination should not affect filiations already established. Donor-conceived children should be given the option to contact the donor as well as possible half-siblings after their 16th or 18th birthday, subject to certain conditions being met. This meant a tremendous step forward, I think. In 2022, a law came into force in France that lifted the anonymity in gamete donation going forward. Regarding the past, the option was left open for donors to reveal their identity so that people born with their genetic material can know their origins. In 2023, a new special law on the protection of children's rights was enacted in Chile. Among other important developments, it recognized a right to learn about one's own origins, including biological. The last measure I propose is the guarantee of determination of maternity by childbirth. Since the Romans, we all have affirmed the mother is always certain. Why? Because throughout history, the mother has been the woman that has given birth to the child. Childbearing is a fact for a woman difficult to hide. Affirming that maternity is established by the fact of childbirth fortifies the child's connection to the birth mother, offering a clear, natural basis for the maternal relationship. Maternity by childbirth is a principle that challenges the notion of children as made-to-order products and aligns with the objectives of a UN surrogacy ban, but by reinforcing the intrinsic value and dignity of the child's birth process. It also supports the abolition of practices that may obscure the child's understanding of their maternity, further protecting their rights and welfare. Determination of maternity by the fact of childbirth deters the donation of eggs. Even if the childbearing woman is not genetically connected with her child, she is profoundly involved with him. In modern times, we have enormous amount of scientific evidence that supports the reasonability of the rule of the determination of maternity by the fact of childbirth. All this evidence relates to the profound symbiosis of the mother with the child during pregnancy. The child's blood circulates through the mother's veins. The child's cells repair the mother's brain. The welfare of the mother during pregnancy is connected to the future health of the child. Consider the following. Childbirth is the result of a time of gestation that produces bodily and brain changes in both the mother and the child. The mother's voice, taste, and body odor shape and develop the child's sensory systems during gestation. The psychic changes of the pregnant woman contribute to the shaping of the child's future personality. Maternal attachment begins during pregnancy and prepares the woman to the physical presence of the child in front of her. Really, the mother remains marked by the child even after pregnancy and delivery. The child is also indelibly sealed by his mother. For the child, nothing is more certain in her identity than her birth mother. In summary, the integration of these measures into the discourse on a UN ban on surrogacy for child welfare provides a comprehensive framework for protecting children within the realm of surrogacy and assisted reproduction. By ensuring rigorous suitability screening of commissioning parents, abolishing anonymity in gamete donation, and guaranteeing the determination of maternity by childbirth, the international community can take significant steps in safeguarding the rights, dignity, and well-being of children born through these technologies. Such a holistic approach not only addresses the direct implications of surrogacy, but also tackles the broader ethical and legal challenges posed by assisted reproductive technologies. It reflects a deepened commitment to child welfare, reinforcing the global resolve to treat children not as commodities, but as individuals with inherent rights and dignity. Ultimately, every child was thought and made by the hands of God. Every child is a gift of a loving God. Thank you very much.